Hi, everyone. So, yesterday I discussed the Massachusetts Supreme Court case of Kegler versus Attorney General. We heard oral arguments from the attorney representing the appellant. I think that attorney did a very piss poor job. I know there weren't very many people here yesterday, but I don't mind. I mean, you guys you caught the replay. You gave me some comments, so I did want to follow up on this because I didn't realize that I would have so much to say. So I'm going to break this up. Today, we're going to review the arguments presented by the Attorney General. And then there was an amicus present or appearance. And I'm not sure if I'm going to get to that today. I may have to break it up into three parts, but today we're going to review the arguments presented by the Attorney General. So, for those of you who aren't here, just post your comments so that if you have any questions, I can address it if I end up doing a part three.
Good morning. May it please the court. Assistant Attorney General Maria Granick for the defendants. To begin, I would like to express the defendant's immense compassion for Dr. Kligler. I would also like to note at the outset that this case does not turn on resolving the policy question.
Just to remind y'all, for those who did not catch the live stream yesterday, Dr. Kegler is a physician who has stage 4 cancer, and he's been suffering some physical problems, and he's basically trying to avoid a painful death. And under the Massachusetts common law, it's not criminalized under statute, but under common law, the physician could be prosecuted for manslaughter if they were to prescribe him medication. So this is the attorney general basically trying to defend the state for denying this terminally ill man the right to die.
Of whether or not the practice that the plaintiff's term medical aid in dying should be legalized in Massachusetts. Instead, this court should affirm the Superior Court's grant of summary judgment to the defendants because there's no fundamental constitutional right to assistance in suicide.
And just to remind y'all, I've talked to y'all about summary judgment. Summary judgment is where the judge issues a judgment based on the pleadings. There is no hearing. I mean, there is no trial. There's been times where I requested a jury trial because the jury is supposed to be the trier of the facts. But if the facts are not in dispute, then the judge can make a ruling based on the law. So I prefer a jury trial because I think the jury should be the trier of the facts and the law. But if they grant summary judgment, then basically the government gets away with whatever they want.
The policy discussion about the pros and cons of legalization properly belongs in the legislature where it is currently taking place. As the Superior Court correctly noted, medical aid in dying raises difficult moral, societal, and governmental questions, the resolution of which requires the type of robust public debate that the courts are ill-suited to accommodate.
Why should there be any public debate on it anyway? This is the problem that they don't understand. We have a Republican form of government, right? And there's a distinct difference between Republican form of government and a democracy. Under a Republican form of government, the government is supposed to represent the interests of all. They're supposed to protect the rights of the minorities, right? This is why Emma Goldman was talking. I'm going to get to Emma Goldman. Emma Goldman was an anarchist writer. She was talking about how democracy only benefits the majority, but it really is tyranny for the minorities. So when it comes to democracy, the public only has a right to vote on public issues. They're not supposed to have the right or the power to vote away your individual rights. So if it's your life, right, that's what the Constitution, the due process clause says, that no person shall be deprived of life, liberty, or property without due process of law. By denying this man the right to die, the state is taking his life for a public purpose without just compensation. they're taking his life because he doesn't get to do what he wants with his life, and the public should not have a say in this.
Because there's no fundamental right to assisted suicide,
But is there a fundamental right to suicide?
there's no fundamental right to
Is
suicide.
that based on,
It's not that there's a fundamental right to suicide, it's that the right to life includes the right to die. I mean, again, the attorney who appeared for the appellant, he did a very piss poor job. I mean, not if I would be so arrogant to say I think I could have done a much better job. Only, I mean, when you get a case like this, if you're not well versed on the arguments for the right to die, you're just taking this case because you're trying to make money. You really haven't given much thought to this. I could present more compelling arguments than that attorney. Um, Unfortunately, I'm not licensed because I don't think the way the government wants me to think, so I couldn't pass their arbitrary examination, aptitude test slash character and fitness requirements. So, um, but at the end of the day, I could actually be a more effective advocate for people like him who are not going to be able to find a good attorney to represent because they don't care. I mean, if you listen to that attorney yesterday, he wasn't making very strong arguments. It was just just lackadaisical, just pulling stuff out of his ass. He wasn't really good on his feet. If you were to put me in that situation, I could make more compelling arguments because I have thought about this long and hard, and I've researched the cases on this. I don't know the Massachusetts case law, but I know the federal case law when it comes to this. Um, this is a whole mess. I'm so glad that I don't have to rely on attorneys that I can actually represent myself.
tradition and history, as one of the amici argue, or is it based on religion, as another amici argues? What's the origin of that prohibition on suicide?
The prohibition on suicide and assistance in suicide is grounded both in historical and legal tradition. As the Supreme Court has recognized, there's no fundamental right to receive assistance to suicide, and no other appellate court in this country has ever recognized the fundamental right. So
This is the problem with the Dobbs decision. The Dobbs decision was overturned Roe v. Wade. They said there is no fundamental right to abortion. No, the Constitution does not create rights. The Constitution is an enumeration of certain rights which existed under natural law, but it's not exhaustive. Rights don't come from the Constitution; they come from natural law. The government is they're flipping the argument. They're trying to say that he doesn't have the right. No, the government does not have the authority, and they can't articulate what their actual interest is. They try to do so in the amicus appearance, but the way that they present it, you have to assert that you have a right to do something because the government creates rights. If the government doesn't say you have a right, then you don't have a right. It's like, no, the government did not create you. These are rights that exist under natural law. Even animals have the right to die. So there are some things which are beyond the scope of government. And I would implore people to read the Ninth Amendment. The Ninth Amendment is the forgotten amendment. Rights don't come from the Constitution. It explicitly says that. That the Constitution should not be used to disparage rights retained under common law. So, gosh, but they don't teach this in law school, right? The way that attorneys are indoctrinated in law school is to believe that rights come from the courts.
And I guess what I'm getting at is underneath this, I know tradition, is there a religious component to this? That the reason we have historically prohibited it based on religious belief?
there's not in the historical and legal tradition recognizes various justifications for the prohibition on suicide, and one of the primary ones being the state's important reasons in protecting the life of all of its citizens.
How are you protecting the rights of the citizens by denying them the right to do what they want with their lives? It's their lives. So what they're saying is that their interest in protecting your right supersedes your own interest. So it's almost like you have a nagging, overbearing, hoovering parent who's so concerned about you. So um, they're basically just going to tell you, they're going to micromanage your life, and then if you don't do what that parent tells you to do, then somehow you're violating that parent's right. So the government is the victim because you won't let the government control your life and make your life a living hell. I don't understand this. I mean, this is indefensible. Um, this is an anarchist, which I'm not sure if I'm going to get to him, but he wrote about, or yeah, this is an audio book on YouTube. I'm not sure if I'm going, but he addressed all this stuff that basically. And anyway, I'm not going to get into. I may come back to him at some point. Yeah, let's just keep going.
So there's not, we would submit, this is not grounded in the religious worldview or a moral or ethical judgment about suicide. Rather, it's rational for the legislature here to prohibit medical aid in dying as it prohibits other forms of assistance on
Well,
suicide for reasons that we outlined.
Determine whether we're dealing with heightened scrutiny, strict scrutiny, or rational basis, let's take a
I told you. I mean, I discussed that with y'all yesterday. There's three levels of scrutiny: rational basis, intermediate, and strict scrutiny. Strict scrutiny. I mean, this is an equal protection case, and so it would be. Again, I think the attorney did a piss poor job. So the way that he framed the issue is that this is about a patient's right to direct their own medical decisions. I think it should have been framed more so as a patient's right to life, and that would have entailed a higher level of scrutiny. But to direct one's medical decision, no, that's just rational basis. Like that. I mean, well, yeah, and even the way he presented it, he just didn't do a very good job. But I would have argued completely differently, and I'm not saying that I would necessarily win, but they would have had a much more difficult time, um, turning me away. They would have had to actually do some homework to refute my arguments.
step back, because one of the most important points about the appellant's position here is that there's really not a difference between the right to reject medical care and proactively be able to receive a prescription and end one's life when you only have 6 months or less to live. And I know that the response is, well, rejecting medical care is
Hello, glad to have you here during the live stream. Let me know if you have any questions as I'm going through this.
it's a battery to have it happen to you if you don't want the care. But that's not necessarily the case.
It's a well, not necessarily a battery, but the state is still violating your right because they're preventing you from terminating your own life. So, the battery doesn't come until they enforce it, right? The battery is that if the doctor prescribes the medication, then the men with guns will come to throw him in the case. So that's the battery.
In brophy, sometimes the way somebody is dying is removal of life support. You have, as the plaintiffs point out, Mo, and we have other circumstances where there's something proactive that happens.
Again, this is a dog and pony show. Most of the time, the justices have already decided how they're going to rule. So he's trying to act like he's being neutral. He's being a devil's advocate. He's trying to hear both sides and be impartial. No, he's already decided how he's going to rule. Like this, I mean, they do this. This is such a spectacle.
Cause the death. Even palliative care sometimes can be proactive as well. So why aren't they right?
Well, we don't rely solely on the passive-active distinction here. I think the important distinction, as this court recognized in Brophy, is that the right to refuse medical treatment is grounded in the interest in avoiding non-consensual invasion of bodily integrity. And though the patient who has received medical treatment has to have consented to it initially. And if the patient's consent or, and by the way, in this context, we're not only talking about competent patients, there could be substituted judgment. So if the patient withdraws the consent and has the right to have that medical treatment withdrawn, and that's a very different situation in terms of the kind of right to
I
privacy.
understand, I understand our case law, but they're making a good point. As there's advances in palliative care and in circumstances like Brophy, it's not stop doing what you're doing, it's actively doing something. And that their view, as we analyze this constitutionally and the liberty interest and equal protection in this context, that it's blurry.
Well, it would be a radical expansion of the kind of a privacy or liberty interest involved. And moreover, as Justice Seifer noted, this liberty interest that the plaintiffs articulate, if recognized as a fundamental constitutional right, would have to be available to everyone rather than patients in this limited group.
Bingo. It would be available to everyone. So that's what they're really afraid of. They're going to let this man suffer an excruciating, agonizing pain, death, because they're afraid that the rest of us may take advantage of it. I mean, but why shouldn't the rest of us have that right? I mean, again, I think that attorney was playing it safe because he was afraid of this, but it didn't help him anyway. By playing it, I think he should have just laid all his chips out and let the judge make the court make a judgment or issue their opinions on it, because I think he avoided those issues which need to be addressed. Why don't the rest of us have the right to die?
Of people who have 6 months prognosis and are competent.
By the way, I don't think that it should just be for those who are terminally ill. I think anyone who doesn't want to be here, who's competent, who has gone a mental health evaluation to make sure that they're not crazy. I think anyone should have the right to die, even if they're not terminally ill. I don't know. I mean, yeah, I know that's extremely controversial, but I don't think anybody should have to be miserable against their will. I don't think that anybody should have to be forced on antidepressants. I think that should be an inalienable right. It is an inalienable right that the state is violating. So I think anyone should have the right to die. It's your life. You should be able to do whatever you want with it.
And able to self-ingest the medication.
Why would it have to be available to everybody? Why couldn't it be a subset of patients who have this fundamental right to direct their medical care, whether by stopping or affirmatively allowing medical care?
If it would depend on how the fundamental right is defined in this case, and here I would argue that it's not. It hasn't been well defined, and it's rather broad and understood in terms of really the right to control the time and manner of one's own death. And if it's conceived in that way, there wouldn't be a constitutional line that this court could draw between allowing it for certain patients who are, as I said, for example, able to self-ingest the medication, and others who are not and would like the doctor to administer the lethal medication, or those who are competent versus those who have made the decision that this is how they would like to die when the time comes.
Your argument isn't so much that it can't be done. It's that it does require a system of regulations on when it could be done, which suggests maybe it's most appropriate for the legislature to define a set of rules for when something like this could happen.
Correct. My point is that the legislature could rationally draw the line by prohibiting all forms of assisted suicide, as it has done so far in Massachusetts, but it could also draw the line differently while putting in place all these important safeguards that are.
But why would the legislature do this? And again, I'm going to get to democracy. but democracy only serves the interests of the majority. So the majority, if all these people are Pollyanna and they think life is a gift and it's so wonderful, the majority is going to oppose the right to die. They want you to be here in a perpetual state of misery because misery loves company, and because they're afraid of their own mortality. So I mean, I've already talked about this. That people block out the fact that they're going to die. I don't know why people think they're immortal. They never actually think about the fact that they're going to die until they are terminally ill. They don't think about the fact that their babies are going to die. Who was it that it was Carl Jung. Carl Jung. I've addressed all this stuff. Y'all can go back and listen to the content. Actually, I think I made that members only, but I can make that. I can I can do a replay on that.
Discussed, for example, in detail in the amicus brief by the Mass Medical Association and the Hospice and Palliative Care Federation. But if a
So courts, even though this is a common law crime, courts are sort of institutionally inept at drawing these kind of really rules about how this could be done.
That's right.
Well, the plaintiffs would respond to that we have all sorts of complicated medical issues, and we nonetheless have a standard of care that develops, and that a standard of care is developed in Oregon, standard of care is developed in I think 10 or 11 other jurisdictions, and that the medical profession is up to a standard of care developing here.
It's true that the practice has been legalized in the United States and the District of Columbia. However, in all of those jurisdictions, it was legalized by statutes, and those safeguards and regulations were carefully debated as a matter of policy by the legislature and were carefully articulated in those statutes. And again, if you look at the differences between
So were you saying the legislature set the standard of care in those statutes?
That's an excellent point. I've also pointed that out, the fact that criminals have the right to die. So in order to have the right to die, you would literally have to murder someone. Like, I mean, come on, that's really sending the wrong message. Why should a law-abiding citizen have to suffer an agonizing death when criminals have the right to die?
That's right. And in Massachusetts, there is no general standard of care that would apply to this situation, which is, would be brand new in Massachusetts, but it also is fairly new in other states that have recently legalized it, and the standard of care that applies to the medical profession as a whole has not developed. And in fact, even though the Mass Medical Society has recently changed its position from opposing physician-assisted suicide or medical aid in dying, and changed its position to neutral engagement. It has not said that it endorses it. So it's something that's in the process of evolving and developing, and this court would preempt the regulations and the safeguards that are so important and necessary by a constitutional ruling.
Counsel, you say that, but if it's our common law evolves, right? A little while ago, you said that if we were to take Justice Lowy's question about not just say when you want to refuse care, but when you want to embrace care, in this case, the whatever prescription it would be that would lead to someone ending their lives on their terms. Why can't we say that we didn't have all of this stuff when we made these decisions, and the common law evolves? And 100 years ago, you were just forced to die this painful death, and that's all we could expect from you. But we've advanced in medical care, and if we recognize this right, why wouldn't it encompass this? Because there are some things, I was waiting a while, but some things that struck me about what you were saying. You said the states has this important interest in protecting all of its citizens and their moral and societal and public interests.
And she already said it. What they're trying to protect is they don't want other citizens to be able to have the right to die. So they're going to sacrifice this terminally ill man so that people like me don't exercise the right to die. This is really sinister. this is evil. Um, I don't think that. I mean, just because the majority does not want me to have the right to die, um, individual rights cannot be put to an individual vote. It's not your choice. You are forcing me to be a slave. And when I say that that they're enslaving people, I'm not talking about chattel slavery. Um, but you know what? Actually, it is chattel slavery. You don't actually own your own life. Your life is owned by the public. The government owns you, and then okay, this is what I'm going to get back to the whole democracy thing because what's his name? I can't remember the name of the author. But he was basically saying that those who participate in democracy are part of the conspiracy against the rights of men. Um, because it's not the government that is doing this, it's the public that is doing this. They're the ones who don't want you to have rights because they want this monolithic way of existing. um, we can blame the government all day long, but it's the public that is doing this. Most people don't support the right to die. Most people would want to force you to die a slow, painful death.
Who's looking out for Dr. Kligler as he's dying, and he's dying painfully? What interest do we have in that? What interest does the government have in that? Can you explain that to me? Because if you take those two parts, the common law involves, and that it may be that now we have these newer, more humane ways of addressing someone's end of life. And in his own home, after living his own life, what interest does the government have in telling him, we're not going to let you end your life on your terms. We want you to end it on ours?
I'll take the second question first, and I would say there's absolutely no reason that anyone should die a painful death. And in the state, palliative care, excellent palliative care is available to many people, unfortunately not all and not all the time, but there are various ways.
It's not just physical pain, it's also about the mental trauma of um knowing that you're going to die and putting your family through this. There was a recent interview, which I'm not sure if I'm going to get to. This woman who was suffering from seizures and losing her cognitive functions, and she was really worried about the impact it was going to have on her family. Um, Palliative care is not going to do anything to resolve any of those issues. Just putting people on pain medication, that is not the only issue. Your quality of life is going to be significantly diminished. Um, the things that you enjoy about life. I mean, it's there's a lot of assumptions being made here, right? The assumption is that life is inherently viable in and of itself, and that just by keeping you alive and the fact that you're not in pain, that fixes the problem. It's a prophylactic. It's not a prophylactic. If you don't, if you can't do the things that you enjoy about life, then is life worth living? It's not. So man, the attorney for the appellant did a very shitty job. If I had time, I would have filed an amicus curiae. I don't know if they would have allowed me to present arguments. I wish I had time, but again, I'm a wage slave, so I don't have time to do things that I think are important. And I'm not a citizen of Massachusetts. I don't know if they would have let me appear anyway, but I think I could have done a much better job.
In which patients at the end of life, as patients throughout their life, can access pain relief and other forms of, as I mentioned, palliative care and comfort at the end of life. So that's not what I'm saying at all. What I'm saying is that the state has an interest in protecting all of its citizens, and therefore, because there's no fundamental right, it can balance the various interests, and it can draw the line at what's permitted and what's not in the way that it has done, and say that while patients can get relief in other ways, they don't have the ability to control the exact time and manner of their death. And if the legislature decided, as a result of debate, to move the line, it could do so, but it hasn't so far. And then turning to Your Honor's first question, I would point this court to a quote from the Supreme Court's Obergefell case that says history and tradition guide and discipline this inquiry, the inquiry of identifying and protecting fundamental rights, but do not set its outer boundaries. That method respects our history and learns from it without allowing the past alone to rule the present. And I would say that in this case, it's not at all a question of allowing the past to rule the present. It's a question of allowing the present to rule the present. And again, in this practice of medical aid in dying, though it is becoming available to a small number of people in this country, it has not yet been something that this court can look to and say it has developed. There's no history or tradition, legal tradition, to guide and discipline the inquiry.
Attorney Granick, let me just ask, you said earlier that this was not rooted in religious or moral sensibilities. What is it rooted in then? Because just, you know, the quote that you gave us from Obergefell goes against you, doesn't it? We're moving forward. As Justice George said, common law changes. And so are you then saying that, yes, at some point we'll get there, but we're not there yet? Is that your point?
I'm not saying that necessarily we would, but I'm also not saying that it's impossible that at some point this would be recognized in a way that the court would be able to reevaluate it. But I'm saying at this point.
Why isn't that now?
Right.
This is the case we have right now. Why isn't it time to recognize that patients like Dr. Kigler have the right to decide in their own way, on their own terms, how they want to die, as opposed to waiting and being limited to the palliative care and dying in hospice?
Because this right, as described, and however compelling and difficult the example here and then the plaintiff situation is here that the state recognizes, there's no well-defined contour of the fundamental right. There's no limiting principle. So if you were to recognize a fundamental right to control the manner and time of death, as I said, it would be difficult to cabinet to this very specific situation and a very limited group of people in the way that
counsel,
plaintiffs have proposed.
I understand your point. What if, would it be possible for this court to say, oh, yeah, you know, there's under the order to liberty analysis, there's a right to determine the time and manner of death, and then say, go ahead, legislature, you go ahead and regulate this. Do we have that authority to tell them what to do?
But the legislature's ability to regulate would then be constrained by a constitutional dimension to this practice, which has never been recognized anywhere, and I would argue should not be recognized by this court, partly for that reason that the legislature.
I just want to clarify what she's saying is that this whole notion of judicial supremacy. We're supposed to have co-equal branches of government. We really don't. The Supreme Court is actually higher than all other branches of government because constitutional law trumps statutory law. And so the Supreme Court's interpretation of the Constitution would trump a statute. And so basically the courts have the final say. So what she's saying is if the court issues an opinion on it, that would basically tie the legislature's hands. But no, not necessarily. It depends on how the opinion is written.
Has to put in place the important safeguards.
But if there is a constitutional right, the legislature's regulation always has to comply with the Constitution.
That's correct. And that's why I would say that the Constitution, that the argument that there is a constitutional right in this case has not really changed from the way that this argument was presented to the Supreme Court in Glucksberg or Vaca.
No, but we're talking about the Declaration of Rights, and you talk about, I don't know, maybe we'll get there at some point in time. And I understand that the Constitution's an organic document, and so I understand that point. But if we might get there at some point, why are you saying that the normative values to infuse some meaning into whether the penumbra or due process is going to exist in 3 years, but it doesn't exist now.
I wouldn't put a certain number of years on this.
Just by way of example.
But go back to that quote about the history and tradition to guide and discipline the inquiry. And I would say at this point in time, we have absolutely no foundation in history or tradition or legal tradition or medical practice for
No, but
allowing.
we're not all prisoners of 1780 or 1789. I'm just trying to understand when you say we may get there at some point in time, and I understand and respect the United States Supreme Court decision under their Constitution. I'm asking you, why it is, if this is an organic document we're interpreting, what is it about normative values that doesn't allow us to say that there's this liberty interest now?
And I would just ask this court to come back to, the case that we have before, the case you have before you today, in which you have a patient who might become terminally ill at some point, who would like access to lethal medication to self-ingest and end his life, and I would argue that there's no foundation under this court's precedent or under the Massachusetts Constitution to recognize a brand new fundamental right to have assistance in dying in that situation or any other.
Can I ask you how this act fits into the crime of involuntary manslaughter? What's so involuntary about this act?
So the involuntary part, I would argue, goes to the point about intent. So
But it's an unintended cause death. You have to intend the act. You have to intend to lock the doors. You have to intend to, or an omission. You have to intend to walk away from the fire. You have to intend to sell drugs, right? That's the intentional act is, we'll throw the cinder block off the highway, right? Those are the intentional acts. You have to not intend to cause the death, right? It just has to have a likelihood. Here, there's certainly an intent to cause the death.
well, the plaintiffs point out that in some cases, the doctor might write the prescription for intending to bring relief to the patient and maybe perhaps even hoping that this lethal medication will not be used. But in this case,
Which could lead to, I think Justice Seifer alluded to second-degree murder under third-pronged malice. And is that what we want when we have, as has been pointed out, advanced palliative care, which hews very closely to this practice?
so on the elements, we argue because of this court's precedent in applying the elements of involuntary manslaughter to other cases in which the victim's death is self-inflicted, those are the elements that may, in the right circumstances, apply more properly. And I didn't get the question about
But I guess, take the drug overdose. Even with fentanyl and Carrillo et al., the purpose isn't to have the person's life end. The purpose is to have a commercial transaction to sell them drugs, and it's an unfortunate, too familiar consequence of an overdose. Here, the purpose is to give them the choice to end their life, correct?
Yeah, and I think I would say, going back to the point that there's an element in which what the plaintiffs are seeking is an advisory opinion, because we don't have all the facts that could potentially go into, what kind of homicide could be charged in this situation. So under the right circumstances.
His physician needs to wait and see? Is that your position, that we don't have an actual case in controversy because?
So that's the whole issue. You have to have standing in order to challenge a statute on constitutional grounds. That's why Dr. Kevorkian went ahead and terminated his patient's life on video and dared the state to have him prosecuted. And the first time he assisted someone, but then the second time he actually euthanized the person on camera, and they didn't prosecute him. They prosecuted him the first time, but not the second time. So they're not going to do it. Like, you got to call, but at the end of the day, there aren't going to be any doctors who are willing to take the risk, because Dr. Kevorkian lost his medical license, and most doctors don't want to lose their livelihoods over this. They're not that interested in this.
Because go ahead, write the prescription, see if we decide to prosecute you later on. And meanwhile, Dr. Klinger is either going to get it or not to get it, and
Right, so
his
it's-
doctor's going to take the risk.
Right, so the doctor has to raise their hand and subject him or herself to a 20-year felony or a life felony?
And I know that this court could find that this case is not a proper vehicle for declaratory judgment and leave the complex policy questions involved to the legislature. So I'm just pointing out that it's important to note that there's so many factual permutations as to the intent and the competency and the voluntariness of the action that this court does not have before it in the current case.
So are you making a separation of powers argument, or are you making a ripeness argument?
I would say both, but again, the Superior Court denied the defendant's motion to dismiss, and the defendants did not appeal it. I would say, this argument is not waived and is still before this court, but, ultimately, the issues as they concern this case are also before this court, so I'm not saying this court couldn't decide it, but I'm just saying it could also affirm the grant of summary judgment on any ground.
Okay, thank you.
Thank you.
And we have Attorney Sandoval.
Okay, so there is an amicus appearance. Let me see how many people are still here. Do y'all want me to keep going, or y'all want me to break it up and do a separate video? I'm going to do a separate one because I don't think the people are going to listen this far into it. So I'm going to come back and do a part 3. So thank you all who are here. The part 3, I'm going to try to get done maybe during a week or so. So I will be back soon. Thank you.